Welcome to This Week in Education Law, where I share up-to-date court decisions from the perspective of educational administrators and policymakers. This is episode 32. In this episode, I focus on a case about Florida's Individual Freedom Act, also known as the Stop W.O.K.E Act. This law bans certain mandatory workplace trainings that espouse, promote, advance, inculcate, or compel beliefs related to race, color, sex, or national origin that are deemed offensive by the state of Florida. Specifically, the law prohibits training that suggests any race, color, sex, or national origin is morally superior or inferior to others, inherently racist, sexist, or oppressive, or responsible for action committed in the past by others of the same race, color, sex, or national origin. This law applies to Florida K-12 schools and higher education institutions. This law seeks to bar employers from holding mandatory meetings for their employees if those meetings endorse viewpoints the state finds offensive. But the meetings on those same topics are allowed if speakers endorse viewpoints the state agree with or at least does not object to. A group of companies challenged this law, arguing that the law violated their rights to free speech and prohibited them from sharing their viewpoints. They also claim the law is vague and overbroad. The district court granted a preliminary injunction against the law, reasoning that the mandatory meeting provision is both unconstitutionally vague and unlawful content and viewpoint-based speech restriction. Florida appealed this decision. The 11th Circuit Court of Appeals affirmed the district court's order of preliminary injunction against the law. The court rejects the state of Florida's argument that the law regulates conduct, not speech. The court reasoned that by limiting its restrictions to a list of ideas designated as offensive, the act targets speech based on its content. And by barring only speech that endorses any of those ideas, it penalized certain viewpoints, the greatest First Amendment sin. The comparative freedom to regulate conduct sometimes tempts political bodies to try to recharacterize speech as conduct, but hiding speech restrictions in conduct rules is not only a dubious constitutional enterprise, it is also a losing constitutional strategy. When the conduct regulated depends on and cannot be separated from the ideas communicated, a law is functionally a regulation of speech, and that means we treat it just like any other content-based speech restriction under the First Amendment. Here, the Individual Freedom Act prohibits mandatory employee meetings, but only when those meetings include speech endorsing certain ideas. The Act officially regulates the mandatory nature of banned meetings rather than the speech itself. And the fact that only mandatory meetings that convey a political message and viewpoints are prohibited makes quick work of Florida's conduct, not a speech defense. If Florida disapproves of the message, the meeting cannot be required. This is a direct penalty on certain viewpoints because the conduct and the speech are so intertwined, regulating the former means restricting the latter. In short, the disfavored conduct cannot be identified apart from the disfavored speech. That duality makes the act a textbook regulation of core speech protected by the First Amendment. The court also concluded that Florida's law failed to withstand strict scrutiny, the most stringent standard of judicial review. It's rare that a regulation restricting speech because of its content will ever be permissible. To pass this highest level of scrutiny, laws and policies must meet two criteria. First, they must be justified by a compelling government interest, meaning the purpose behind the law or policy must be of paramount importance and not merely a matter of general concern. Second, The measure taken to achieve this compelling interest must be narrowly tailored to achieve their objective. To fulfill the compelling purpose, the law or policy must focus with surgical precision and not necessarily or excessively restrict constitutional freedom beyond what is required. This means the law or policy must use the least restrictive means available to achieve the intended outcomes, ensuring that the laws and freedoms protected by the Constitution are infringed upon as little as possible while still accomplishing the law's essential goals. Florida's law failed to meet the two criteria of strict scrutiny. First, the law lacks a compelling governmental interest. The state of Florida argued that its compelling interest was to protect individuals from being forced, under the threat of losing their job, to listen to speech espousing the moral superiority of one race over another. Proclaiming that an individual, by virtue of his or her race, is inherently racist, or endorsing the racially discriminatory treatment of individuals because of past racist acts in which they played no part. However, the court reasoned that many people find those views deeply troubling does not mean that by banning them, Florida is targeting discrimination. The concern that certain viewpoints might cause discomfort does not justify a blanket prohibition. Discrimination, by definition, means treating people differently. The Florida's law in question does not specifically address differential treatment. Rather, it imposes restriction on speech accessible to all employees, irrespective of their personal agreement or disagreement with the content. The Constitution firmly supports the principle that public discourse, even when it includes ideas that some may find offensive, should not be stifled, even if we presume that the act served the interest of combating discrimination in some way. Its breadth and scope would doom it. Banning speech on a wide variety of political topics is bad. Banning speech on a wide variety of political viewpoints is worse. A government's desire to protect the ears of its residents is not enough to overcome the right to the freedom of expression. Florida's law in question also failed to be narrowly tailored. The law was not narrowly tailored to achieve its purported objectives without excessively infringing on First Amendment rights. By imposing a blanket prohibition on a wide variety of discussions and viewpoints under the premise of preventing discrimination, the law overstepped by significantly restricting free speech in educational and workplace settings. This broad approach did not consider or implement least restrictive means that could address the state's concern while preserving the fundamental right to free speech. This case is about the W.O.K.E. Act and addresses the regulation of content and viewpoints, particularly regarding race, color, sex, or national origin. Educational institutions often deal with similar content in their curricula, training programs, and initiatives. What can educational administrators learn from this case? First, educational administrators must strike a delicate balance between upholding free speech and preventing discriminatory practices. You will need to navigate these waters very carefully and ensure that policies do not inadvertently suppress legitimate discourse. This means creating space where open dialogue and diverse perspectives are not only tolerated but encouraged. Shielding students, faculty, and staff from challenging discussions does not facilitate learning or growth. Rather, it hinders the development of critical thinking and the ability to engage with complex societal issues. Emphasizing respectful discourse and critical engagement over prohibition offers a more constructive path forward. Second, when implementing mandatory training or educational programs, particularly those addressing sensitive or controversial topics, educational administrators should critically evaluate whether those programs might be perceived as endorsing specific viewpoints. The training should be informative and educational, rather than advocating for or against specific ideologies or perspectives in a manner that could be construed as discriminatory or exclusionary. The training should also present a balanced view on contentious topics, allowing participants to explore different viewpoints and form their own informed opinions. Educational institutions' training programs should respect free speech and avoid imposing ideologically based training in a way that could be construed as compelled speech or viewpoint discrimination. In the end, the training cannot be content or viewpoint-based speech regulation.